In December 2022, a pivotal shift occurred in the Australian employment sector, marking a significant stride towards fostering a safer and more inclusive workplace environment. The Anti-Discrimination and Human Rights Legislation Amendment, Respect at Work Act 2022, came into effect, amending the Sex Discrimination Act 1984 and introducing a new approach that mandates employers and PCBUs must proactively eliminate workplace sexual harassment and discrimination. This was not merely a legislative change. It was a call to action, urging employers and PCBUs to transition from merely responding to sexual harassment and discrimination incidents after they occur to actively preventing them from happening in the first place. The new positive duty imposes a legal obligation to take proactive and meaningful action to prevent workplace sexual harassment, sex discrimination, and related victimisation from occurring in the workplace or in connection with work. But what does this mean in practice? Employers and PCBUs are now legally bound to take all reasonable steps to eliminate a spectrum of unlawful behaviours, including discrimination on the grounds of sex, sexual harassment, sex-based harassment, conduct creating a hostile workplace environment on the grounds of sex, and related acts of victimisation. This shift towards prevention rather than response requires a recalibration of workplace policies, practices, and culture. It necessitates a proactive approach to identifying and mitigating risks and implementing strategies and initiatives that foster a safe and respectful working environment. The Australian Human Rights Commission will have new regulatory powers to investigate and enforce compliance with the positive duty commencing in December 2023. This provides employers and PCBUs with a transition period to ensure compliance. However, the call to action is immediate. The Commission is developing practical education and guidance materials to assist employers and PCBUs in understanding their responsibilities and implementing necessary changes to meet these new legal obligations. These materials are progressively being made available on the Respect at Work website and the Australian Human Rights Commission's website. The question that arises is what constitutes all reasonable steps to prevent a contravention. It includes 1. Considering the size and resources of the employer. 2. Taking steps to prevent sexual harassment. 3. Focusing on what steps would or might prevent an employee from sexually harassing a person. 4. Requiring an adequate sexual harassment policy and periodic communication of the appropriate policy. 5. Providing training to employees on how to identify and deal with sexual harassment. 6. Implementing a procedure for dealing with sexual harassment complaints and taking prompt action if and when sexual harassment occurs. And 7. Deterrence, through education that sexual harassment is unlawful and has consequences for the employee or agent. If you find yourself navigating through the intricacies of these amendments and need guidance on how to optimally comply with them, the Williamson-Barwick team is here to help, so please get in touch. Williamson-Barwick can provide appropriate workplace behaviour training to your organisation.